Hi, everyone. Welcome to the Pipeline Fighters webinar series. The Pipeline Fighters is a project of the Bold Alliance. We're an organization that works across the country, helping landowners and communities fight infrastructure projects that threaten the land and water. Bold is mostly known for our work around the Keystone XL pipeline, where we proudly stood with farmers, ranchers, and tribal allies, as well as climate advocates for over a decade to protect property rights here in Nebraska, where we got founded, but all across the Midwest. The Midwest is now being threatened by a new type of pipeline called carbon pipelines. And the Pipeline Fighters Hub has done a series on carbon pipelines about the risks, about the threats, around the lack of regulations at the state, local, and federal level. And today we're focusing in on what a pipeline easement is, what actually is in the pipeline easement, more importantly, probably what is not in a pipeline easement, and why it's so critical to join the easement action team if you are a landowner being threatened by one of these carbon pipelines. So your property rights and your negotiation power is really strengthened by joining a group of people who are in the same boat as your family. We will then hear from Paul Blackburn, who will talk about the 45Q tax credit, which is something that the federal government has passed through several administrations, both Republican and Democratic. Under the Trump administration is when it got very profitable for pipeline companies to now be proposing all these pipelines that are going across the Midwest. So Paul's going to talk a little bit about that, plus also answer a lot of questions we've been getting from landowners about what does it mean when a pipeline company comes to my county board meeting or our state legislature and they brag about all these tax dollars that they're going to be paying into the state or the county. So Paul's going to talk a little bit about that and how they sometimes use misleading information to get people on board with their project. We'll leave plenty of time for questions at the end. You can always ask a question in the chat function. We are going to try to have people take themselves off mute when we get to the end of Paul's presentation. So you can ask your own question in your own words, but you can also type it into the chat as well. So with that, I'm going to pass it first to Brian Jorde. He is the lead attorney for the easement action teams. We have easement action team groups happening in Iowa, Nebraska, South Dakota, and North Dakota. And he's an attorney with the Domino Law Group and is, from my perspective, the premier expert on pipeline easements and eminent domain in the country. So take it away, Brian.
Thank you, Jane. Appreciate that. Folks, we're going to jump right into it, and I'm going to share my screen here, given we have a short time. And so what I want to talk to you about is kind of the nitty-gritty of these easements. And by way of brief background, as Jane mentioned, right now, we're working on specifically on the CO2 pipelines, multiple pipelines in different states from Illinois all the way up to North Dakota. What I have here as an example is the Summit Carbon Solutions map. And you can see the different easement teams in each state that are dedicated to that. We've also done work in the past in Wisconsin on Enbridge pipelines. Obviously, Nebraska, Keystone XL. There's also multiple pipelines in Nebraska as well. And so a lot of what we're going to share about today is the kind of education and information a person, a landowner, would get if they join the easement team and participate in that. So what's an easement? Well, you are unwillingly being asked to sell something that you didn't have for sale. In a sense, you didn't want to part with certain property rights, but you're being confronted with the threat of eminent domain and therefore this idea that you will voluntarily negotiate. So an easement is a grant of certain property rights to someone else or another company on, under, across, through your property to do whatever it is it says in that easement you have agreed, or the pipeline company in this case has told you they will want to do with your property and how they want to use your property. You still own the land, so you still pay all the property taxes. They don't pay property taxes on your land if they're only taking an easement, whether it's temporary or permanent, okay? So you pay the property taxes. They don't contribute to that. You have liability, which we'll talk about. They get to come in and out as they so choose at will to use it, to inspect, investigate, etc. They propose to pay you one time in today's dollars, not inflation adjusted, no present cash value for the life of the pipeline or the project. And then this either occurs by agreeing with them on terms if you determine or you decide to negotiate, or through the condemnation process. So let's see. Yes. So landowner rights. Well, if you're going to negotiate an easement contractor, you're confronted with one, you better know what are all your rights. And so obviously you have the right to the surface of your property. You can occupy it. You have vegetation rights. You can plant trees, crops, etc. You can improve the property via structures, pivots, grain bins, sheds, whatever it might be. You have rights beneath the surface, subsurface, or subterranean rights. You have air rights above your property, and you also have the right to be free from interference of public or private nuisances. So these are what we refer to as the bundle of rights, a bundle of sticks that each represent a rights that represent fee ownership in your land. And what the pipeline company who wants an easement wants to take away some portion or some percentage or some degree of one or more of those rights. And so if you are going to be confronted with something like this coming through or near where you're living, or something like this right in your front yard, you're going to have to either be willing to read through and research and understand all of this, right? The proposed easement and all of this, the rest of the proposed easement and the other parts that I haven't put in here, or find someone who really understands it and knows what they're doing. So let's just jump right into this. I'm going to give you kind of the high level analysis so you have some takeaway, so you understand some of the problems that are confronting you here. Easement agreement, we start at the first paragraph. Try not to be seduced by looking for the dollar amount. That's the mistake most landowners make. They go to a dollar amount, get fixated on negotiating that, and you forget everything else, which is exactly the bait that the pipeline companies want you to bite on. So right out of the bat in the first paragraph, you need to ask yourselves, who am I dealing with? Who are future generations, the next people that are going to be the stewards of my land dealing with? Do you know, for instance, who Summit Carbon Solutions LLC is? What type of company are they? Who are the owners? Who has interest? Who has controlling interest? What are the assets? What if something goes wrong or there's a catastrophic rupture or leak? Are they going to have the assets to stand behind their end of this agreement that they want you to sign with them? Be advised that they want the agreement to be able to pass through their successors and assigns, which means they can assign their rights away, any number or degree of them, to someone else, and you don't have any veto power of who you might be dealing with in the future. You are granting, or they're asking you to grant rights. So the first paragraph here has to do with granting, and that's for use by the company, and then a long list of other people, pretty much anyone and everyone. So it's not just the company, it's anyone and everyone else, such as third-party subcontractors and other entities or companies that you may not want to have anything to do with, but you now will be stuck with. They want a grant for a pipeline easement in this instance. They specify how wide it is, typically 50 feet. They want the right to change the slope, the grade, to fill in low spots on your property, which may or may not be a problem. But if you're dealing with production agriculture and drainage, they have the right to forever change the way your property naturally drains to fit their purposes. Now, how could that affect you in the future? It could reduce yields. It could cause all sorts of problems. They have the ability to later relocate and change the route. So you may have agreed, okay, this route makes sense, even though I don't want this, but I'm going to go ahead. I think I have got and negotiate a fair deal. They come the next day and say, well, remember in the right here, it says we can change it or relocate it. So that's what we're doing. They can abandon in place. If you don't have protections within your agreement, thinking about whether or not it's abandoned, and you don't have state laws that deal with reclamation, abandonment, and how you're to be treated, you better be negotiating that for yourself on the front end if no one else is out there looking after you, which is typically the unfortunate case. Here they say one pipeline not to exceed. Oftentimes you say easements that you see easements that say one or more pipelines or just pipelines, and just that one letter S at the end of pipeline could really put you in trouble in the future when they come back around and don't want to pay you a penny more because you or 3 generations ago signed an easement that had an S after pipeline rather than specifying one. In this instance, they specified carbon dioxide, okay, and then they say, and a pipeline that could also transport any of carbon dioxide's naturally occurring constituents. What are those? Not defined. How wide-ranging is that? And associated substances. What's that all about? We better get more specific now. There may be something in the future that you don't want that they claim they get by this catch-all language here. And they want to potentially have the right to put above or below ground facilities that would do what? Inhibit your development, your natural and kind of continuous use of maybe future development of your property. They may also want a temporary easement, but guess what? There's not a definition on what temporary is. Is it 1 month? Is it 2 years? How long does this linger on before you should have received more money? But you thought it was temporary, you trusted them, it wasn't defined. You need to work on figuring out and putting guardrails and bookends on what does temporary mean. Again, within temporary, they say for the purpose of all these different things. So basically they can do anything they want to your land, even in the temporary easement, even abandoning in place in a temporary easement, which doesn't make much sense if it's a temporary easement because you couldn't abandon something forever in something that's supposed to be temporary. So you'd want to get that out of there. They also want an access easement. Well, most people think, okay, I have a 50-foot strip of permanent easement. Maybe there's another 60 feet of temporary easement running parallel where they store equipment, where they stage different things during the digging and trenching. Well, and they have to get to it. Well, that's fine. Shouldn't they just go down the easement? It depends. If you don't negotiate in your contract what the access easement is and what the restrictions are, they can go all around your whole yard, your land, your field, your pasture, whatever it is, to access in whatever means and mode they deem the most reasonable, cheapest, fastest, best for them. And then you think, whoa, I thought this was just about a pipeline. Well, remember that access easement? Yeah, we can access this anywhere we want. You note the last sentence there says access easement may not be specifically shown on Exhibit B. Well, of course it's not, because they want to be able to do it wherever they want. So you better think about and negotiate that. Location, obviously you want to negotiate the location so it's the least inconvenient as possible for you. Damages. This is pretty important. So what they want to do is get you to agree to waive and be paid for as many damages as possible now. They want to pay you once for the permanent and temporary easement, but they also want to pay you once and upfront for any crop damage, any other property damage, regardless of how bad it might be in the future, because they want to limit their risk. And so they'll waive the dollar signs. And if you don't pay attention to what's referenced here, damage calculation sheet, and if you don't realize by signing and accepting that, you waive your right to ever go back against them for any other damages, because they come along and say, well, remember 5-10 years ago, we already paid you for all this. Yeah, but I didn't know it was going to affect my yields for 6-7 years. Well, too bad, so sad. You already agreed. We got you. You better be thinking about that. What about restoration? Well, they have all this fun language. Basically, we'll return your land, to as good as condition as it was before, insofar as reasonably practical. And who is the arbiter of that? Well, they are. You're not. They say your land may be permanently modified. So they warned you. They say as may be reasonably required or to as nearly reasonably practical. Again, what does that mean? You're going to have a fight over that because on one hand, especially folks from the Midwest and rural folks tend to be trusting. Well, you said what's reasonable. Don't make the mistake of thinking they're reasonable and you're reasonable are anywhere in the same universe. They talk in these paragraphs of restoration, land restoration, that the company shall at landowner's option repair or replace if they injure or damage tile or irrigation. So that seems fine. Or pay landowner the cost to repair the tile. Well, what if you get a bid that's more than they want to pay? Then well, that's not reasonable. And now you're in court fighting over what's reasonable, why they're not paying you when you thought, well, you would just do the work and submit an invoice and boom, you get paid. It doesn't work that way. So I should say you want to think and specify, right, all these things. Landowner's use, back to those rights that we talked about earlier. So subject to the following subsections, right, and all this language that follows, they say the landowner may use the easement area for any and all purposes not inconsistent with the purposes set forth in the agreement, which remember is anything in their sole and exclusive determination. So basically, they can forbid you from doing anything as long as they in their sole determination claim that it's inconsistent with their either access to the easement or use of the easement and operation of the pipeline or whatever infrastructure they're putting on your property. You can see there at company's sole discretion. So if they believe, well, what you wanted to do, you wanted to build something here or add a fence here or do underground, you wanted to add irrigation on your field, for instance. No, we think that could cause a safety hazard. It's our sole discretion. You don't get to do that. And now guess what? Your land isn't as productive. Again, if in an agricultural example, it's not going to command the best price whenever you go to sell it because they have limited your rights. They have taken them from you. So you have to be thinking of all the future problems that could occur. It goes on to say, without limiting the generality of the previous statement, and then the landowner is not permitted. So then they put specific things you're absolutely not permitted to do. And that goes on and on and on, again, in the sole discretion of the company. So if you're not negotiating this on the front end, once you've signed this, it's too late. You've given them the sole power to determine what you can and can't do. Then it goes on at the bottom, talks about, if you do anything without getting their permission, which they're unlikely to ever give you because they don't have to, any remediation on their part is at your sole expense and they'll come and sue you for any reimbursement. And that you must promptly reimburse company. You didn't see promptly reimburse earlier when they were saying you would be reimbursed. Interesting how the word promptly wasn't there. And that they can remove and tear out any infrastructure you put in there without liability. So let's see. Now, it also goes on to say, landowner may not have use of the easements for any purpose. Again, to in any way impact the construction or compromise safety, all in their sole discretion. So you can imagine how wide-ranging that can be if they have sole discretion to prohibit you to do certain things. Now, indemnification. This is one we need to talk about for just a little bit. Indemnification. So that means basically that you or they will hold harmless and they will allegedly will hold you harmless from any problems related to liability or loss or personal injury, except, however, such claims. What's a claim? Anybody can make a claim. It's not a truth, a universal truth. It's any claim. It's any allegation of liability or damages as may be due or caused by the acts of the landowner or basically anyone you've allowed to be on the property. Well, who is to determine caused by? Well, that's what we have trials and juries for. So you're going to fight and be in litigation over that. And you can rest assured that if there is some catastrophic damage that occurs on your property or potentially that you could be found liable for, or they could pull your insurance company or your assets into the fight to help spread out to pay any damages from other lawsuits they face. They will pull you in to get your pot of money in there and allege any type of claim to tie you to the potential proximate cause or contributing factor of whatever the damage was. Think driving a very heavy piece of equipment across an easement that later has determined to have a bit of a fracture or a break, and now we have a catastrophic rupture or release. Well, why were you doing that? Did you check with us? Didn't you know that was one of the things you weren't allowed to do? So you really want to be thinking about what this indemnification means and this carve out here before you just stop at the first part of the clause. You got to keep going, right? The accepting or the notwithstanding all the foregoing, right? Those kind of tricky clauses you have to be really careful of. They can moot out everything that occurred before that new phrase comes into play. Assignment. They can assign this contract. And look what it says. Companies shall have the right to sell, assign, apportion, mortgage, or lease. So they don't want to pay you a lease on an annual basis, so this can become more of an asset that's income generating over time. They want to pay you once, but they retain the right to get lease revenue on a periodic basis for your easement that they only paid you for once. That doesn't sound too fair, does it? They want to be released from any of their obligations if they assign or sell the easement to third party. Again, it could be to the United Arab Emirates, Saudi Arabia, it could be to anyone. You can't stop them. But yet they want liabilities for you to flow through your heirs and assigns and people that come after you. And here in the assignment portion, it interestingly says for the first time that the pipeline easement and access easement shall be permanent. Are they trying to hide that? Why wasn't that language up when we're talking about the easement and the access easement? So they are permanent. Let's see, landowner liens. So they have the right, or you consent that they can contact any of your lenders, your banker, mortgagee, or anyone else holding a lien. They can talk to them, they can try to get documentation from them, they can try to get your bank to sign off on certain things that they need, they can get access to your private documents, loan documents, etc. You're agreeing to that right here. You're agreeing to fully cooperate. And then it says, well, landowners won't be required to incur any third-party out-of-pocket expense in connection with helping them, right, get all this documentation. But there's no compensation for your time. There's no compensation for you taking time off work, running around, trying to phone call people, getting busy signals. What about that? They're just saying that they'll take care of third parties. So you basically become their secretary and you run around and do whatever they need to do, and they're not going to pay you for that. Again, they mentioned abandoned in place. We've seen that in here 3 times. That probably gives you a good tip of what their true intentions are. So this is kind of the closing last slide, because I want to leave plenty of time for questions on all these topics at the end. But here's an exact example out of a client I had in Nebraska of the advanced release of damages and indemnity agreement. So remember, they come with the easement that is a couple pages. It references out to advanced damages computation or claim, Exhibit A, Exhibit B, Exhibit C. And what's the common, what do you typically do? You look at the easement, you flip to where the price is, you look around, I don't know, it's probably hopeless, I'll just sign it. You're not looking at all these things. That is where really the meat of what's really going on is. So what does this say? Well, this says they offer a sum of money. And what does it say? This sum of money is in full payment today before we've even done anything. We haven't probably surveyed, we haven't constructed a pipeline, we haven't had any problems, we had to investigate. It's not 10, 20 years in the future. It's right now, before anything goes wrong, in full payment and settlement in advance for all damages listed on the advanced damages computation form. So you better go look at that form. What are you signing away now? What rights are you giving up to go back at them in the future when it's like, holy smokes, my yields were cut in half here. Too bad, so sad. Remember this advanced damages computation form? you sign them all away. And in consideration of this payment, which is measly certainly in the scheme of things, you and anyone that comes after you, whether you die and a personal representative takes over, whether it's your family, whether it's the person you sell it to, they are stuck with what you had agreed to 10, 20, 30, 40, 60 years ago, and they don't get to come back for any other damages that are being released. And you can see the language, it goes on. You're releasing and forever discharging company. And remember the definition of company, it's not just Summit or TransCanada, it's anyone that they assign to. So no one in the future will ever have to pay you anything under this breakdown and format here. And then of course, at the last little part there, it's essentially any claims of anything that you shall or may have in the future. We don't know what we don't know. We don't know what could happen in the future. Maybe the land use changes. Maybe it's near town and it's going to grow houses in the future. Well, guess what? Now potentially you've cut all of that out by the existence of the pipeline easement, the nature of this contract, what you can and can't do. And so the long and short of it is, folks, there's so little that you really know unless you're doing this all the time, which is not a slight. It's just, you don't want to have to deal with this, right? And so if you were going to get surgery, you probably would find a surgeon who does whatever that surgery you need. And you'd probably think, well, have they ever done one before? Oh, they have. Okay, good. And so don't make the same mistake and try to perform your own surgery. When it comes to this type of negotiation and analysis, you really want to work with people that have done it before. So the long and short, don't sign an easement, especially if you're in the early phases. The pipeline companies don't have local, federal, state approvals. Wait till they have all the approvals. Wait till all of those fights have been waged and hold out. And if you have to negotiate at the very end, make sure you join up with a group of folks and a team that can help you out and get you the best deal you can if you have to get to that point. So with that, I will stop and hand it over to Jane and Paul, and then I'll be here to answer questions at the end.
Thanks, Brian. And there's already folks who are posting questions in the Q&A. So if you have a question about easements and terms or the contract, the easement contract that one of these pipeline companies has already put in front of your family, you can start to put those in the Q&A button on the bottom of the Zoom, or you can put it in the chat. So those are two places. And just a reminder, if you are not a member of the easement action team yet in your state, this is the time to get on board, because that's when we can then tell the pipeline companies and the media and your county officials, we have 100, we have 200 members in your state that are now joined with the easement action team, that are standing strong together, that are not signing easements. We know in the future, if we're unable to stop these risky pipelines, you may join the easement action team because you want a better contract and you want better price. And then there's landowners that join with us because they want to try to stop the pipeline and are doing everything they can. And they want as many people to see that happen, because they don't see this as a positive for their land, for their community. So I strongly encourage you to join the easement action team. We're always here for these type of education sessions, but when you join the easement action team, you then have actual legal representation, which is the difference. So with that, I'm going to turn this over to Paul Blackburn. He's going to do some slides and some educating about the taxes, the 45Q tax credit, what exactly that is, as well as what type of taxes pipeline companies pay.
Hello, everybody. So yeah, I'm covering two very different topics. One of them is the 45Q tax credit, which is about how to avoid paying federal income tax. And the other is about the tax revenue that pipeline companies claim that they're going to provide as a state property under state property taxes. So the 45Q tax credit really doesn't have anything to do with the state property taxes, but we're going to try to cover both of them anyway. So let me do a screen share here and move right into some presentations. Just take a second. Okay, am I good? Did everybody see this? Good. All right. So I call this the Federal Pipeline Development Gold Rush, and folks should understand that the 45Q tax credit is essentially creating the development incentive for these pipelines, the Summit Navigator and ADM, and also the conversion of Trailblazer to CO2 pipeline service. So this is really a federally spawned industry. So what is a tax credit? Well, a tax credit is the amount of money that a taxpayer can subtract directly from their taxes, from the amount of tax owed. It's not like a tax deduction, which lowers the amount of taxable income. It's really just reduces the amount of the tax owed. So if a company owed, $100,000 in taxes and it had $90,000 in tax credits, they just subtracted it and end up paying $10,000 in tax credits. And this is one of the ways that corporations and very wealthy individuals can avoid paying taxes, and we're all familiar with that. So how does the tax credit work? Well, the tax credits create a financial incentive for taxpayers to take an action desired by the government. So, for example, a lot of people are familiar with the federal wind and solar energy production tax credit. And in this tax credit, for every megawatt of energy generated by these facilities, the owner of the facility is granted a tax credit. The 45Q tax credit is similar for each metric ton of carbon captured or sequestered. The tax credit, the owner gets a tax credit and gets a reduction from its federal taxes. And how much money is at stake? Well, starting in 2027, and that date is really important, the tax credit will be $50 per metric ton for carbon sent to sequestration sites and $35 per metric ton for carbon sent to enhanced oil recovery facilities or other types of use. And we'll talk about the merits of those numbers in a second. But perhaps the most important thing related to 45Q tax credit is 2018, Congress, originally the 45Q tax credit had a cap on it of 75 million metric tons of CO2. So once that cap was reached, the program was ended. In 2018, Congress just completely removed the cap for the 45Q tax credit. So that means essentially, if a company, the amount of tax credit is unlimited. If companies can get tax credits for any amount that they seek, that they're able to capture. So, for example, the 3 supercritical CO2 pipeline projects proposed for the Midwest alone, this is Summit Navigator and the ADM Wolf pipeline. The maximum tax credits they might be able to claim together would be $23 billion, over 12 years. So that would be a reduction in federal income by $23 billion over 12 years. But these are just the first wave of 45Q tax credit CCS projects that have been proposed. Likely, there's going to be many more proposed, especially in the Gulf Coast. That 2027 start date is critical because as long as, and actually that they have to qualify by having the project under construction by 2026, but as long as they can get their projects going by 2026, then they can get a tax credit. Well, in the Midwest, there's all the regulatory requirements for pipeline approvals, but in Texas and Alabama, Mississippi, Louisiana, there are essentially no regulatory processes. So they can announce these projects in 2025 probably and start construction right away and have them in operation by 2027. So they don't need to be announcing their projects down the Gulf Coast. We have seen some preliminary announcements down there, but we don't have a lot of detail about them. But suffice to say that there'll probably be many more projects announced because frankly, this tax credit is so generous that companies are salivating to be able to use them. Yeah, so if you consider that just the first 3 are $23 billion over 12 years, the total program cost could reach into hundreds of billions of dollars over 12 years. So this is just some figures from the 3 announced in the Midwest, and you can see here's the number. This is again based on the maximum capacity of the pipelines. They may not get this much, but it shows you the order of magnitude that we're talking about here in terms of dollars going to these projects. So as I said, well, why the rush to build? Well, because the start date, they have to start construction by 2026 and the tax credit peaks in 2027. All the companies are waiting time on target to get the projects done and underway, starting to operate in 2027. So even though the tax credit was changed by Congress and made more generous in 2018, all the companies are waiting to start their projects operation until 2027, because then they can maximize their tax credit. Right now, those figures, the $50 per metric ton and $35 per metric ton, those amounts aren't available until 2027. And the tax credit is, granted to the entity that owns the carbon capture equipment and ensures sequestration or use. But this tax credit may be transferred to sequestration or EOR site owners, enhanced oil recovery site owners. So talking about the merits of those numbers, the cost to capture carbon depends on the type of emitting facility. There's not one basic cost for capturing carbon. And the cost is primarily dependent on two physical factors. And the first is the concentration of CO2 in the emission stream for the facility. And the second is the presence of contaminants. The lower the amount of CO2 in the emission stream, the more equipment, the more chemicals are required to capture the CO2 and remove and separate it from other kinds of gases. And the more contaminants there are, the more there have to be processes to remove those contaminants for a variety of reasons. So some facilities, such as ethanol plants, have a very high concentration of CO2 in sort of the 98% range, and relatively few contaminants, although there are some. So the cost for carbon capture of these facilities is typically in the $25 to $35 per metric ton range. So that means with a $50 per metric ton tax credit for sequestration, they're getting between $25 per metric ton and $15 per metric ton of tax benefits net of the cost of the project. Now they also have to pay for the pipeline and for the sequestration sites, but still this is enough to more than pay for these and to provide a really generous profit. So that's why these companies are all jumping in. But if you compare the cost of carbon sequestration at power plants, refineries, and chemical plants, the cost to capture the carbon there, because the CO2 concentrations are much lower and there are many more contaminants, is going to be probably in the $50 to $150 per metric ton range. So right now, carbon capture at these kinds of facilities generally is not economically viable. So we haven't really seen proposals at these facilities yet. But there are proposals to increase it. These are some of the legislative in Congress on proposals to increase the tax credit. You can see here figures like $85 per metric ton or $60 per metric ton. Different kinds of facilities get different kinds of capture. But suffice to say that if the carbon tax credit jumps up to these levels, one of the problems is that one size fits all is a really bad idea when it comes to these tax credits, because you could be providing an $85 per metric ton tax credit to a facility would only cost $25 to remove the carbon, or you could, and that may be the $100 per metric ton might be enough for a power plant, and it would still earn a profit, but just not as much. But this one size fits all could result in some wildly profitable carbon capture facilities, and just simply wouldn't be fair or equitable. Other countries are trying to handle this in different ways. For example, Canada provides a tax credit based on 1% of the cost of the facility rather than just a flat one size fits all. So who can claim the 45Q tax credit? Again, the entities that can claim the tax credit are whoever owns the carbon capture equipment initially. And those owners may be owners of individual pieces of equipment and may be owned by corporations or partnerships, could be owned by individuals. So there could be many different owners for the carbon capture equipment. And then each of those owners could transfer some of the tax credits to a sequestration or enhanced oil recovery facility. and all these sequestration and enhanced oil recovery facilities could also be owned by individuals, corporations, partnerships, and joint ventures. So suffice to say that there could be scores of entities that might be getting tax credits from each of these CCS projects. And when you think about that in terms of these are just the first 3 projects, and there could be dozens of projects, you can see that potentially thousands of entities could be claiming the 45Q tax credit. So what agencies are going to regulate the tax credit? Well, the Internal Revenue Service, manages tax credits, and they have this little short 2-page form 8933, which you could fill out as there's like 8 check boxes and 16 fill in the blanks on it. It's really summary information, sort of bottom of the page stuff. But the IRS does require additional information to be provided via model certificates, but these certificates are not mandatory, and claimants could use other forms if they want to. They just have to provide the information. So the IRS doesn't really require any standardized online reporting for any of the detailed information required that Congress wanted them to gather. And this absence of standardized reporting is really problematic in terms of managing and monitoring this program and preventing tax fraud, because I just don't see how the IRS can get lots and lots of PDFs or hard copies from thousands of tax credit claimants in different formats, and then try to make sense of all that information. I just don't see how they can do it, especially when the physical information related to sequestration or the sequestration and enhanced oil recovery only has to be kept by the claimants for 3 years. So, unfortunately, it doesn't appear that the IRS is ready to bird dog these projects and to manage it. The IRS also relies on the US EPA for technical enforcement, meaning keeping track of where the carbon really goes. But EPA's regulations here were designed to protect water quality. They weren't designed to enforce a tax credit. And it's not clear that the EPA's regulations or data requirements are sufficient to support the IRS. And I'm not really sure that we should rely on the IRS and EPA working hand in glove to manage this entire process. So I'm going to talk about for tax credits, and I'll be able to answer some questions. And let me move to my other presentation here, see how I'm doing time-wise. Talk about state taxation here. So, the presentation I've subtitled Exaggerated Promises and Future Risks. And again, this is about the claims by pipeline developers that they're going to pay, how much taxes they're going to pay, and how the state taxation system works. So sorry, this is kind of dry, but taxes are just simply really dry most of the time. So do pipelines pay state property taxes? Yes, they do, but property taxes for pipelines are not the same as home property taxes. They're more in the nature of a personal property tax rather than a real estate property tax. That being said, to the extent that a pipeline company actually owns property, that property is included within their taxes. Pipeline developers always argue that potential tax revenues justify new pipeline construction. And we'll talk about whether they're accurate in that later on. And while tax revenue can provide a benefit, data from reports filed by TransCanada Keystone Pipeline LP, that's the owner of the Keystone Pipeline in eastern North Dakota, South Dakota, Nebraska, and as well as Kansas and Missouri. This data indicates that during the permitting, it substantially overestimated the potential tax revenue that would be generated by this pipeline. So how do these state property taxes work? Well, there's statutes and regulations and court decisions, and they're different in every state. So it's possible to generalize to a degree, but it's really important to look at each state's laws. Still, generally states follow standard appraisal methodologies, but these methodologies and state laws usually allow a considerable amount of flexibility when estimating taxes. And states also may grant tax relief before or during a pipeline's operation. They can just cut the tax rate if they want to, or do a development incentive of some sort. And pipeline operators should be expected to lobby and or sue for tax relief. For example, my memory is that the Keystone 1 pipeline was granted tax relief by the state of Kansas, and it appears from some of the tax data I'll show you later that the state of North Dakota just cut its taxes for pipelines at some point, and I believe in 2014, probably because they're making tons of money on the fracking boom, and they were just cutting taxes in general, but I haven't confirmed that. So how does appraisal for property taxes or pipelines work? Well, the standard reference book for property tax assessment, or property valuation assessment, is the appraisal of real estate, and is published by the Appraisal Institute. It identifies 3 appraisal methodologies: the cost approach, the sales comparison approach, and the income capitalization approach. I'll talk about each of these separately. These approaches can produce really dramatically different property valuations and result, depending on how they're used, they can radically change how much money a county could receive from a pipeline company. So the cost approach, well, this is basically looks at the cost of replacement of a pipeline, its original development cost, essentially, adjusted for inflation minus depreciation, and then adding the land value that's real estate that's owned. So you could kind of say this is the book value of the pipeline, and pipeline companies report a version of this value to the federal government in their Form 6 forms and as a net carrier property. So it's basically the book value of a pipeline. The next approach is the sales comparison approach. And this is what people are familiar with homes. You look at what other sales in your neighborhood are for homes, and you see at homes of similar size and similar quality, and then you can try to get a sense of what the value of a home would be if it's going to be taxed or sold. But since pipelines are infrequently sold, they do get sold, but not often. And each pipeline is a unique asset. It could be 10 miles long, or it could be thousands of miles long. It could be 5 years old, or it could be 50 years old. This approach of sales comparison just generally isn't ever used for pipelines. Then the third approach is this income capitalization approach, and this essentially looks at how much money a pipeline is generating, and then based on that, it calculates what a willing buyer would pay for that pipeline based on its income generating potential. It's a bit complicated process, but essentially it bases the taxes on how much income a pipeline is producing. But this is the important thing here, is that depending on market conditions and or a pipeline owner's management decisions, its income could be substantially reduced. And this substantial reduction in income could have a dramatic impact on the tax valuation. And this actually happened in Minnesota. We'll talk about that in a few minutes. So how do states look at these three, really the 2 methodologies, the cost approach and the income approach? And it depends on state law. Some states preference one approach, some states will weight both approaches. But as I said, the change in assessment methodology can have a really dramatic impact on assessed value and county tax revenue. And states perform the valuation. Typically what happens is states perform the valuation assessment for all the counties in the state. They look at the value of the pipeline throughout its range, even out other states. They figure out how much value that pipeline has within a particular state, and then they divvy up the value among all the counties. And so, this is called a state assessment process. I think I've just covered this already, but I'll move on. But it's just important to understand that these pipelines, the state will winnow it down and say to the county or to a school district or fire departments or whoever the taxing entity is, here's your share of the pie. And then, but then the counties or the taxing agencies will be responsible for actually sending out the tax bills. So here's an example of Nebraska's tax assessment process. Nebraska revised statutes here say that the pipeline are taxed as public service entities, which is a utilities tax. Nebraska generally requires the use of the cost approach, this book value kind of approach. But a pipeline company may submit a petition to consider other assessment approaches like the income approach. And the state law requires that the state determine the amount and then it's divvied up to the counties. Minnesota's is a bit different. I'm not going to go through this in the same detail, but Minnesota says you're going to look at both the cost and income approach, and the default weighting is 50-50. So we'll average them out essentially. But again, pipeline companies may challenge this, and in fact, Enbridge did. And otherwise, the system works similarly to Nebraska. So what can go wrong? Well, a pipeline company may challenge the value assessment methodology, and if successful, the pipeline company maybe do a massive refund. So what Enbridge did starting in 2016, they filed a case in the Minnesota Tax Court, and they said that the cost approach should only weigh 20% and the income approach should weigh 80%. That may seem like a relatively small difference. It resulted in a tax refund to Enbridge of tens of millions of dollars that was due to be repaid by low population northern rural communities. And if they had tried to repay these tens of millions of dollars, this is like per county, they would have gone bankrupt. So the state had to bail them out. Now, like I said, Nebraska has the same right to gives pipeline companies the same right to make the same kind of arguments. So, just because Enbridge said years ago that they would pay a certain amount of taxes, they ended up getting a huge tax cut. And I can go into the reasons why, but essentially my understanding of the situation is that Enbridge management made some serious management errors, and their customers responded by forcing Enbridge to accept lower tariff rates, meaning lower revenue. And that lower revenue meant that Enbridge earned less money. And because it earned less money, it said it should get a tax refund. So, unlike a homeowner where your tax bill is whatever your house is worth, the pipeline company, if they take this income methodology into account, if the pipeline company just simply screws up and earns less money than it should, they can get a tax break for their mistakes. But other things could happen, such as the lower amount of throughput from oil fields going into decline, or other kinds of market-based effort things that could result in reduced income. All those things could result in lower taxes being paid by a pipeline. So one shouldn't consider that these pipeline payments will be fixed. And so do pipeline companies pay as much as they claim? Well, this is data from the Keystone Pipeline filed with the federal government by TransCanada itself. And you can see here that I averaged payments from 2012 to 2021. Now, it started operation in 2010, but for different tax reasons, the full taxation amount typically didn't kick in most states until 2012. So I just decided to take the last 10 years, which I think is a fair amount of data to look at. But you can see that in North Dakota, Keystone ended up paying 30% fewer taxes than it said it would during permitting. In South Dakota, it was 34% less. In Nebraska, it's 1% more, but you'll see the trend on that means that probably it's going to go negative here. In Kansas, is 60% less, probably because of some tax relief provided by the state government of Kansas. Missouri got 18% more than they estimated. So let's look at the charts. So up in here in the corner is Nebraska. So you can see that it's going up, and then it started up in 2012 here, and then it's dropping steadily. Why is that? Well, because Nebraska uses this cost approach. It uses the original cost of the pipeline minus depreciation plus land valuation. And so as depreciation kicks in, the value of the pipeline goes down, and so therefore taxes are going down. Presumably this trend will continue. That means that counties should just simply expect to get less money from TransCanada over the coming years. In South Dakota, I don't know what went wrong there, but they really earned a lot less than TransCanada promised them, and it doesn't appear to have changed based on change in state tax valuation. I just think that TransCanada overestimated the amount. In North Dakota, the original returns are relatively high, but then it dropped pretty quickly. And so in 2014, it was dropped relatively low. And again, I expect this is because of state tax code change, but I haven't confirmed that. In Kansas, down the lower left-hand corner, they've been relatively low and stable with a huge jump recently. And that may be because the tax benefits that they provided ended, and now they're looking at full taxation amounts. So maybe we'll get more in the future. In Missouri, the center lower one, they actually have had upward trends in tax recovery. Now, none of these numbers are adjusted for inflation, so but still, Missouri went from about $5 million per year to $12 million per year, and I don't think that's due all to inflation. So Missouri's had some mechanism within its state tax law to increase its tax revenues. In the lower right-hand corner, it shows the per mile basis for taxes paid by Keystone Pipeline. And you can see that many of them are around $20,000 per mile. But again, Missouri's sort of an outlier, and now recently Kansas became an outlier too. So you can see that in most states, TransCanada underestimated how much taxes it would pay. And over time, it doesn't appear that most of these states are going to go up. But except, well, three of them, North Dakota, Minnesota, Nebraska, and South Dakota, will all probably stay or continue to decline. And Kansas may stay up. It depends if they get a new tax deal. In Missouri, apparently, is going to continue to go up, but we'll see. So thank you for your time. I'm trying to run through a lot of materials. I'm happy to answer any questions. And I'll stop screen sharing and look forward to talking more.
Thank you, Paul, and thank you, Brian, again for your presentation. We're going to go into questions and answers. And I just want to say that, yes, taxes may be dry and boring, but Paul just gave you a ton of information. And I think for me as an advocate, the bottom line is these pipeline companies come into our communities and our states and sell their pipeline project to our elected officials and our candidates by saying that, you know, it's going to bring all this tax money into the state. So therefore, we should essentially just roll over and everybody should welcome them with open arms. And it's really important to put some context into that when you go to your county commission meetings, your state legislature, to remind them that in many states, those taxes aren't paid forever. It's based on the piece of equipment that depreciates, and that it usually is much lower than what they're selling it as. So, and then with the 45Q tax credit, I just want to put kind of an exclamation point on the fact that, you know, this is something that national groups that we're working with are encouraging members of Congress in the budget reconciliation that could still happen this year or next year in budget bills, that they remove the 45Q tax credit. That would obviously be a big deal and victory for those of us who are working in the states if they didn't have that huge money incentive. So that is something that we're all currently advocating and working on. I just wanted to make that point as well. So for one of the first questions Bonnie asked, and Brian, this is for you. If we were to be forced to eminent domain, the landowners, would they be forced to accept the terms that they're currently been put in front of them?
So a nuanced answer. The courts do not get involved in easement negotiations. The courts in condemnation are looking at predominantly a valuation issue. Now, from the work that had been done up to that point elsewhere, and imagine if other people in our group had been negotiating easements, those talks have been going on, we've been getting concessions, it's highly likely that those folks that go through the court process would also get those concessions. But again, it's not, the court system can't force a better agreement. It can force greater compensation for a bad agreement. Okay. And so you look at the agreement and you try to explain and get into valuations if the court will let you do that on an evidentiary basis. But typically leading up to that, the pipeline company has relented to some general modifications and concessions. But one of the keys is if you push them to condemnation, you typically are able to negotiate along that whole way. And you've heard of, the case settled on the courtroom steps. Well, very few condemnation lawsuits go all the way through to a jury verdict. They're often settled ahead of time. So if you're holding out and showing you're serious, you typically have more leverage to then get better terms, even though the jury doesn't rewrite the contract if you go all the way through to the end.
Thanks, Brian. We have a couple more questions, and this one is, I think, pretty specific, but I'm sure you'll be able to answer it on how this impacts, because I know there's a lot of landowners that it might not be going through their land, but it might be going through currently a neighbor's land. So we've experienced this before. But the question is, in the navigator letter that I received, it stated that my home and property is in their quarter-mile right-of-way, though it is in the neighboring field and will be located approximately 1/8 mile from my home. So what exactly does that mean for me? They did state if they needed to that they would use eminent domain. What rights, if any, do I have compared to my neighbor landowner? And what can they actually do to my property without my agreement?
So you are on notice that they may come on to your land in the future. So it's in some ways almost worse, if I could say that, because you're not there, so you're hopeful, but yet you're still staying up at night thinking, well, gosh, could it come here? Should I be doing something? But unless it does come on to your ground and directly impact your property rights, take those rights from you, you aren't able to seek compensation simply because it's nearby. Now, what I would tell you is don't fall asleep on it, because if your neighbor puts up a really good fight and you're not really involved, that might just kind of migrate right across onto you while you thought, oh, this is great, it's on his place, not mine. And so the best thing you can do, you can also join up with an easement team, participate, get out there, spread the word, encourage neighbors not to sign, etc., and still be involved. But in terms of legal rights, unless you have a right that's going to be impacted directly or taken from you, you don't have legal recourse until or if there is an easement on your ground or there's some damage that occurs on your land.
And it's good to remember that these pipeline companies, I often say, put landowners in kind of 3 categories. The first category is those that may negotiate willingly right off the bat and take the first offer that the pipeline company gives. And then there's a middle category that they put landowners in, where they think that those are the landowners that with more money, they would sign an easement, that they're kind of willing partners at the table. And then there's the third category, which is mostly the people in the easement action team that put up a tough fight and don't fall for a lot of the ploys that these pipeline companies give. And it's important to remember that if they think you're in, 1 or 2, they're number one going to offer you less money than if you're in category 3. We have learned this over the past 12 years that we've been working on pipelines. But it's also really important to remember that they may move the pipeline. So it may not be on your property now, but they may be experiencing a string of, from their perspective, difficult landowners, and therefore it might now be on your property, which is why, again, if it's not on your property, or if it is on your property right now, it's important to join the easement action team. The next one is from Gabby, and she asks Brian, first she thanks you for the helpful information, and they're experiencing something in Tennessee. So she's wondering what legal resources and avenue there are for landowners in Tennessee with an existing easement from a very old gas pipeline who are now being told they have to accept a new pipeline on their land. And before Brian answers, Nebraska landowners and landowners in Colorado and Wyoming are experiencing this as well, with a gas pipeline that maybe their grandparents and even great grandparents signed the easements for, but now they want to convert it to a carbon pipeline. So Brian.
Yep. So it goes back to everything we talked about here. How much and how well, if any, was that old easement negotiated? Can the easement be located and found? Because what we're confronted with here in Nebraska is there's a pipeline that clearly is going across, many miles of Nebraska, but you go to the courthouse to figure out, well, what the heck did that original easement say? What rights were signed away on this piece of ground by my great grandparents or prior owners generations ago? And some of them are different. Some have different clauses, some did negotiate, some didn't negotiate, some are better than others, some are non-existent. And so in Nebraska, similar situation, they're trying to do a conversion from a natural gas to a CO2 pipeline, but that wasn't contemplated 60, 70 years ago. And so they are seeking an agreement now to expand rights that don't exist, that as the successor in interest or who acquired old pipeline company that your grandparents dealt with didn't have the rights to do what they now want to do. So it all comes back to find the easement, go to the courthouse, registrar of deeds, recorder, whoever it is in your state and your county, try to get a copy of what the easement is. And that's what it is. If it's not in there, then they don't have the rights. And that's where you want to know what rights were given up. And then is there a way you can get creative in confining the words they used back then to not have a blanket permission to do what they want to do? So at least they have to renegotiate on new project, on new conversion, on next, parallel pipeline they want to drop in next to the old one, et cetera. So you've got to get a hold of that easement, and the easement agreement, the contract, whatever it is called, that will tell the story. So you got to get that, get it to someone that knows what they're doing, and then they can help you read through that and figure out what strategies are available to you.
Brian, for landowners that might be on the call that aren't yet part of an easement action team, can you just walk folks through what that process is and how they become part of the easement action team?
Yeah, I sure can. And that's evolved over the years, and it's a tried and true model. We didn't come up with it last night, been in existence in Nebraska for over a decade. And as I showed you on that map, rolled out to communities and states that have wanted to benefit from this structure and the teamwork behind it. So the easement team model itself is the collection of the actual directly affected landowners, so that they can get together with myself, with Jane and her team, with Paul, with experts that we bring in from time to time, work on county ordinances, work on best practices. I directly advise the landowners on the legal rights and strategies. And then we all kind of come together to try to put on the best case presentation, whatever that may be, to advocate for the landowners, which typically first is trying to prevent or stop the pipeline, trying to promote landowner rights. And then if we get down the line, the easement team, it provides the structure that retains the legal services of myself and my firm. And then we can help either directly fight in court on various lawsuits and challenges that we think are fruitful and would be good for you, such as temporary injunctions to stop surveys, injunctions to stop pipeline companies from doing all sorts of other things, removing property or damaging your land, all the way up to the agency proceedings on whether or not eminent domain should be conferred or granted to the pipeline company, developing experts, and then also the legal expertise to negotiate if we have to, or if you and your individual decision-making feel like that's the best option for your family. And so it's not our way or the highway. It's an entity that works best for you. The primary model that we work on is we've learned that resistance leads to the best chance to negotiate a better easement and get better prices. So even if you're like, well, I don't want to be a part of the resistance, it's part of the method that will get you to the best terms, as opposed to saying, hey, I'm over here, I'm ready to sign, right? Not the best way to negotiate. So there's the easement team that has kind of like the communication, and then separately and within that model, the landowners actually hire myself so we can have a confidential relationship. We can share information. I can advise them legally and ethically. And then those costs are divided equally across all of the people, which is the only affordable way to possibly ever go up against these mega billion-dollar corporations.
Thanks, Brian. Paul, there is a question for you on taxes from Denny, who said that it's their understanding that in Illinois, pipelines are classified as personal property and therefore aren't taxed, except when they come above ground for things like pumping stations. Do you know if that's true, or could you help find that information if you don't know?
Yeah, I actually haven't researched Illinois law. I know that, pipeline companies report paying taxes in Illinois. I'm not sure the basis for it, so I'd have to look into that.
Okay. And then on a related taxes question, Nancy asks, if a pipeline is coming into the state, does the pipeline company split the taxes among all counties in the state, or is it just paid to the counties where the pipeline is going through?
My understanding is that it's paid just to the pipelines, to the counties where the pipeline is going through, because it has to be based on the value of the pipeline within each county.
Thanks. There's another question asking that, the pipeline is not coming onto their property, but it's really within about a quarter mile of where the pipeline would be to their home. And so they're concerned about what happened in Mississippi when that carbon pipeline exploded and caused several people, up to 30 people, had to go to the hospital and get treated. First responders couldn't get to people because their engines wouldn't work with all the carbon that was in the air. PHMSA, as a federal agency, did a major report showing all the major concerns that they now have at the federal level, as well as at the state and local level. So the person asking the question is essentially saying, are they considering us essentially collateral damage? Are our lives essentially acceptable because it's cheaper for the pipeline company to pay a wrongful death benefit rather than deal with all these major safety issues ahead of time?
Well, the answer is yes, absolutely yes. You are collateral damage. And again, it goes back to bad state laws, because the eminent domain is on a state by state basis, and the process of which, if there's a state agency that reviews it, the scope of review, if they're like South Dakota, where they just say yes or no to a line on a map, if they're like Iowa, where they can make individual landowner specific decisions to not give eminent domain on a parcel by parcel basis, or anywhere in between. And so if the landowners outside of the easement, the 50-foot easement, are not protected in some way, if there's not a bond that has to be put up, a gigantic bond or surety to cover any damages, regardless of it's a mile or 5 away, there isn't any money, there isn't any support until after the fact, and it's just everyone scrambling to try to figure out what went wrong. But there's nothing on the front end. Why? Because the lobbyists for these major companies eliminate any type of money and monetary investment that has to be made on the front end if they can, limit that, and then just hope someone else is there to deal with it on the back end when it all goes wrong.
That's right. And I'll just say that the easement action teams in these states are really focused mostly on the easement contracts and eminent domain, and working with Brian's legal team to protect your property rights. And then there's groups in each of the states that are doing the advocacy work at the county commission level, in state legislatures. So in Nebraska, for example, that organization is BOLD. In Iowa, Sierra Club, and Dakota Rural Action, Dakota Rural Council in South Dakota and North Dakota. So I just wanted to mention that, because these are all things that we are strongly pushing at the county and the state level to say, we are not prepared for these carbon pipelines. And if you care about our rural communities, if you care about the folks who put food on your table, if you care about the first responders who would have to be the ones responding, we don't have the proper regulations in place to deal with carbon pipelines. We may for oil and fracked gas, and in some states we really don't even have that. But we definitely don't for carbon pipelines. And so, the more that we do these education sessions, you see on the Pipeline Fighters Hub, we link to a lot of other resources as well. There are a lot of laws that have to be put in place in order to protect the health and well-being of folks in the communities. And that's literally what the governments at the county and state level are supposed to be doing. And I always remind people, I live in a rural community. I live in Air, Nebraska. We have property in Air, Nebraska. I live in Hastings. And so our property in Air, Nebraska is now about 2 miles from one of these proposed conversion carbon pipelines. And the companies, Summit, Navigator, Tallgrass, and Wolf, none of them have yet displayed, given us access to what's called the dispersion model. So we know, because fracked gas and oil pipelines have been around for so long, what the risk level is and how far the risk level is. We don't know that yet for these carbon pipelines. That's something we're digging into. It's something that Brian's legal team is digging into at the Iowa hearings and the South Dakota hearings. Nebraska doesn't have a hearing process yet in place for these pipelines, but that is something that, as we learn, we'll continue to share that information with you. But if you're living near one of these proposed pipelines, but it's not going through your land, you should definitely still be very concerned, because there's real risks that will come along with these pipelines.
And if I could just add, these pipelines are getting their money from the federal government. And so, they shouldn't be cheaping out on safety measures or taking care of people. They should just pay this, and they shouldn't just be walk away with all this money. And in terms of, the potential tax benefits going to counties should really take into account the fact that there are costs as well. Costs for first response, but also there's cost for example, monitoring and maintaining pipeline crossings under roads. And after a pipeline is abandoned, there could be significant costs for dealing with mitigation, filling the pipes with cement or removing them under roads so the roads don't collapse into the pipelines. And we all know that construction costs are extremely high. So, it's entirely possible for the cost of an abandoned pipeline to wipe out a lot of the tax benefits that were seen by a county over the life of a pipeline. And so therefore, it's also important for counties to make sure that they have, and states to have in place abandoned pipeline compensation provisions.
And I think right now there's only a handful of states that are doing that. Minnesota, we tried to get one done in Nebraska. So these are all things that we have to start advocating for. Cindy is asking, how many landowners do you need in a state in order for an easement team to be formed? Brian, do you want to take that one?
Well, I mean, the technical answer is one, if that one wants to front 100% of the cost, right? You don't have to have more than one. If they're, got tons of money and want to pay for everything, then that's fine. But it makes sense to have as many as possible, not only for the economic, but for the volume portion. And what do I mean by that? If I walk into a courtroom and I have one client with me, okay, that's one client and they're important. What if I have 100? And not only 100 clients, but 3 members of their family? Okay, now we've got 400 people and they're standing outside and it's overflow. And the people in the court have never dealt with this big of a crowd. And it's like, wow, these people really care. And the press is there, right? So it's not only from the financial aspect, it's from the earned media, the public perception, the court of public opinion aspect, which is frankly far more important than a lot of other things, right? If we can reshape the narrative by the amount of people that are up in arms and that are actually physically taking action and doing things and showing up and being counted on and speaking out, county commission meetings, political rallies, candidate forum, whatever it is, that's what you need to be successful. From the cost side, if anyone wants to, pay for the whole freight, the one person, but, I'd certainly like to get in the realm of 50 plus when you start to kind of feel good. Also, the more people you have across the state, the better information sharing. And that's really powerful. It's not just what I tell you or Paul or Jane or what, it's what do you, the people on ground zero, are you hearing in the cafes? Are you sharing information you're getting? And we combined all of that and share it in Zooms like this with people all over the state, which is invaluable. And so it's a more robust representation and group and more effective the larger it is.
And we're able to see things that these pipeline companies are doing now across state lines, when before we were really focused kind of on one state, either Nebraska or Wisconsin or Virginia, when we were helping landowners there. But now we're working across multiple states on the same pipeline. And so when Summit, for example, sends their mailer in Iowa that says that they have, I think, whatever it was, 31 miles secured, which is really negligible of what they actually need. And they send then a similar flyer in Nebraska and one in South Dakota. We're actually able to compare the numbers and kind of how they're trying to tell their story in order to try to pressure landowners. which is what a lot of this media work that these pipeline companies do, whether it's directly to landowners or to the public or to your elected officials. They will always try to tell their side of the story, and we always say they never lie, but they never tell the truth. So what they're not saying in a lot of these numbers of land acquired, they're not talking about the hundreds of miles that they don't have acquired. And nobody right now in any of these states is forced to give up their land for these pipelines. And so if you are on the call and if you have a contract in front of you, you're under no time obligation right now to sign that contract. And in fact, it is much better to hold and wait and join the easement action team, so your power of your voice and your family is better protected in the power of numbers. Brian, I know we're staying on until 7, so we have 10 more minutes, and there's some other questions that we'll try to get through. The first one, which I know you or Paul can answer, is can you describe what setback limits are, and does Iowa, for this individual is asking specifically, does Iowa have setbacks for carbon pipelines?
Yeah, I'll let Paul, start that out, and I'll jump in if needed, because that's something we've been kicking around.
Sure. Well, Iowa does not have any setbacks under state law for Iowa. It does grant the Iowa Utility Board the right to determine the route, but the law doesn't actually require that the Iowa Utility Board avoid properties by any set amount of set distance, which is what a setback is. Now, I wrote an entire blog post on setbacks because the pipeline companies, speaking of lying, frankly lie about the fact that they claim there's a federal 50-foot setback, and that is just flat out lie. The law they cite is 49 CFR 195.210, and it says that a pipeline cannot be built within 50 feet of a property unless it's another foot of soil is added on top of it. So all they have to do to build within 50 feet of a property is just pile another foot of dirt over the pipeline and then call it good. Now, there's no practical limitation on where they can put it. I've seen pipelines be built within 50 feet of properties. Like, for example, the Keystone Pipeline in South Dakota went right by people's houses within 20 feet of them. So it's entirely possible for them to build very close. Also, federal law, the statute itself says that the Pipeline Safety Act does not grant the federal agency any right to determine the location or route of a pipeline. So the federal statute itself says that PHMSA can't issue regulations that say what the location of a pipeline is, and setbacks relate to location. So they just simply can't. They can't issue a setback. The federal government couldn't issue setback even if it wanted to. And that rule to be 50 feet, within 50 feet, add a foot of dirt, can't be interpreted as a setback because it would violate federal law. So there are none. But your counties, in theory, in Iowa could impose a setback and have the Iowa Utility Board respect that setback. So you should talk to your county supervisors about that possibility. And we've got model ordinances if you'd like to see how that's done.
Brian, did you want to add anything on that?
No, I think he covered it there. Great. Again, it don't get caught up in, federal law and federal minimums. I mean, I'm dumbfounded that if someone says, well, federal law, and everyone, oh, federal, it doesn't mean anything, right? I've got sheriffs telling me, well, they're federally protected to come and do what are you talking about? It has nothing to do with anything. So again, it goes back to the county board, the board of supervisors, zoning regulations. Get reasonable setbacks that can be defended. Don't try to get a 10-mile setback in, right, from any structure. That's going to you're going to get beat in a lawsuit on that, or the county is if they enact it. How about 1,500 feet? How about 2,500 feet, a quarter mile, whatever, something reasonable. And then to Paul's point, counties in certain states can effectively route the pipeline indirectly by having setbacks in place that then mean they have to zig and zag certain directions, which by definition is then effectively routing the pipeline. So the counties, you got to just really hone in on them and get them to strengthen, to do CO2 setbacks and reasonable ones as soon as possible. And the pipeline companies will come in with their lobbyists and say, you're going to get sued, we're going to sue you. Just like the head of the Republican Party is, their lobbyist in South Dakota. He's threatening and intimidating all the state's attorneys, the county attorneys up there, showing up at all the board meetings, threatening lawsuits. what a great guy and great company to have as our neighbor, right? As they like to say. But don't be intimidated by that, and do everything you can at the county level.
And that actually leads into Jamie's question, which is a really great one, because Jamie says, because it's an interstate pipeline, can the state and especially the county commissions exceed the federal guidelines? Could they, for example, set a 1,500-foot setback in a 6-foot depth? So Paul, do you want to talk about that?
Sure. Well, since there are no federal guidelines for location or route, because doing so would violate federal law, counties and states have complete authority to route a pipeline to determine the setbacks. A state could issue setbacks if it wanted to. You know, the states of North Dakota, Minnesota, Nebraska, Iowa, and Illinois, and other states all route pipelines. If the states can do it, then in a state where the state doesn't have been granted that authority to a state agency, then counties could do it. Federal law expressly says that federal agencies can't determine the location or route of a pipeline. So the location of the pipeline, including setbacks, is not a matter of federal law, period. It just isn't. Now, in terms of depth of cover, that's a really interesting question, because, you know, I've seen the pipeline companies say, well, it's a 3-foot minimum and they're going to go to 4 feet and therefore they're real generous. Well, for oil and carbon dioxide pipelines, federal law says that it's 3 feet, except in agricultural areas that has to be below the level of cultivation. So, you know, this means that in agricultural lands, that the pipeline can be required to be buried deeper than the 3-foot standard amount under federal law. And in fact, Minnesota and New York both have laws that say that, you know, that require deeper burying of a pipeline than 3 feet. So when Summit says that they're going to be going to 4 feet and that's above federal standards, well, the federal standard is actually below the level of cultivation, whatever that means in your land in your state. And so a county, again, could pass a resolution saying that the depth of cultivation in the county is a set amount or below drainage or something like that. And you know, but federal law doesn't actually define what the level of cultivation means. It leaves that up to the state and counties, because, you know, again, it could be different on a county by county, even a property by property basis, what that level of cultivation is. You know, on pasture land, it could be, you know, very little. On places with deep drainage systems, it could be 8 or 10 feet. You know, and federal law specifically recognizes that it's different depending on each piece of agricultural land. So again, you see the pipeline companies lying about what the standards are. It could be up to counties or states to determine the level of cultivation.
Thanks, Paul. And there have been some questions about the links, and I just want to say that we will post this webinar on pipelinefighters.org. And in the blog post that Mark puts up with the webinar that you'll be able to watch and share with others, we'll include in that post all the links that Mark's been putting in the chat. So if you haven't been able to follow those, we'll make sure that that's in the blog post that we put up along with the recording of this webinar. And so with that, I'll just, because I know we're at our time, I will throw it to Brian first, if you wanted to give a minute closing, and then to Paul, and I'll close out.
Thanks, Jane. So folks, just by being here tonight, you're doing yourself a big service, and you do have a voice, and it can be amplified by finding like-minded people and folks like all of us who have been through battles, have the scars to prove it, and the tears and the blood and the sweat, and joining together to fight and to frankly improve property rights, improve landowner protections, and influence legislatures and lawmakers to do what's right, to put the power back on the side of the people and people's rights, as opposed to corporations that come in for a quick buck and disregard your rights. So get involved, join up with an easement team. If you're in one of these states that is affected, obviously, with the easement team and the landowners and Jane and the organizers would appreciate any donations if you're not affected or you're nearby and just want to be involved. But really get involved, make your voice known so we can share information and put on the most successful effort possible. So we appreciate you all.
Paul.
The tax stuff can seem kind of dry, but the truth is that it's the driving economic force behind these pipelines, particularly the 45Q tax credit. And I didn't get to go into a lot of detail, but there are a lot of really significant policy implications of the 45Q tax credit. It's really, really important to understand how it works and how it doesn't work. I've heard a lot of landowners say that it's a scam, and frankly, I wanted to see what I thought myself. So I looked at all the regulations, all the IRS tax forms, all the statutes, all the IRS guidance and all the EPA regulations. And after looking at all that, I think, yeah, I mean, they're going to be able to rip off the federal government blind. There's just simply not nearly enough regulatory structure in place to manage potentially thousands of 45Q tax credits. I mean, the 45Q tax credit could be renamed the get credit for dealing with climate change while getting as much oil out of the ground as possible and not having to pay any taxes while you do it law. This could be hundreds of billions of dollars of tax credits, none of which is going to go to you unless you're really wealthy. The only groups that are going to be able to benefit from these tax credits are very large corporations and very wealthy individuals. This is one of the ways that you hear about billionaires not paying taxes. Well, this is a big way they can avoid paying taxes. And in terms of the county tax payments to counties, counties shouldn't count on whatever is claimed by the companies. The data is just there to suggest that the companies will exaggerate their tax benefits. And again, I've seen counties just get, just really get hammered by Enbridge by going to court and claiming that, because of its own mistakes, it should get a tax break, and they got it. So, folks should be aware that these numbers, this money is really the lifeblood of these projects, and and learn about what's going on with these tax credits and with the taxes, and understand how they really give advantage to a very small number of people and they really harm a lot of other people.
Thanks, Paul. And thank you everybody for joining with us today. And for Mark, who's on the Bold team, who's been handling all the back end. You didn't get to see Mark on screen, but he made all of this happen. And I'll just close by saying we deeply care about you. We do care about our rural communities. We care about the land and water. All of us want to see an end to the use of eminent domain for private gain. It is a driving value that we hold in everything that we do at Bold, at the Pipeline Fighters Hub, and at the Easement Action Teams. So thank you for joining us. Thank you for being part of our family to try to end eminent domain and to make sure that your property rights are protected. See everybody.